Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, how to bind consumer to terms or official rules in light of a recent court ruling. So, what's going on today? Well, first, I am totally choking from this tie, but I wanted to look nice for you, so I hope you guys appreciate it. So, what is it about this new court ruling? Well, the Ninth Circuit Court of Appeal looked at a recent major retailer's website, and although they had a prominent hyperlink to the terms right next to the submit button on their sign-up page, the court held that for purposes of the arbitration clause, the terms were not binding on the consumer under contract law because the consumer was not made aware that it was going to be bound to the terms by submitting their information. Now, you might be able to show that consumers had actual knowledge of the terms, but in most cases, that is going to be really tough. So, what does this new court ruling apply to? Well, it really applies to any terms of use or terms of sale, promotions like sweepstakes rules, contest rules, or free offers, of those kinds of things. Anytime you're trying to bind consumers to official terms or rules. Now, just to be clear, I'm not talking about disclosure of material terms and what constitutes false or misleading advertising. We're just really talking about binding consumers under contract law. Now, sometimes it's less important, like just general terms of your website. But when people are buying things from your website or they're signing up for specific offers like contests and sweepstakes, it's very important to bind them to your official rules. You don't want to make that sale and not have protection in case you had some mistakes on your offer as advertised on the website. And you don't want them to enter your sweepstakes and not have good protection in the event that there are some problems with your sweepstakes down the road. So, what isn't probably sufficient under this contract law? Well, here's one good example. You see the submit button, and then you see that you're going to have to scroll below the fold at the bottom of the website to the terms of use. Now, you might laugh, but that's still what a lot of companies are doing these days. Now, here's another example of what a lot of companies are doing. You see the sign up, you see the official rules link is right next to the submit button. But what the court held in that prior case is it's not enough to have those things close to each other. You need an express statement that by submitting the information, you, the consumer, are willing to be bound by the terms or the official rules. So what should it look like? Well, we'd love you to have a checkbox where by checking the box you are agreeing to the terms. But if you can't do that, it's probably going to be enough that right above that submit button or create my account button, it says something like, by submitting your information, you are agreeing to bound by these terms. And then of course the terms thing should be a hyperlink to the actual terms. We'd also recommend including the privacy policy link in that spot so that your privacy policy is clearly and conspicuously disclosed at the point where you are collecting consumers' personal information. So what is that going to look like? Well, here's one good example. You see the checkbox. Check that box. I agree to be bound by the terms and conditions, which is a web link. Here's another good example without the checkbox, but by clicking on the I agree, you confirm that you have read and understood and accept the terms, and that's right above the I agree, create my account language. Now, here's an example of a good idea, but that just may not work in full, and that is by continuing on this page, you agree to the terms of use for our entire website. Wouldn't that be great if we could bound consumers to all the terms of our website without an account creation just by this language? Now, while I like the language because it comports with that Ninth Circuit decision, the problem is that as you see, this language is below the fold at the bottom of the website where not everyone is going to see it. It would be a lot more effective, probably per the Ninth Circuit, if it was at the top of the website. Now, I recognize you're not going to do that in all cases, but like I said previously, in all cases, it's not critical to bind people to your terms. It's really most important when you're selling something or getting them to sign up for an offer that you are making. So that's it for today. I hope you enjoyed it. For more information, follow me at Brian Heidelberger on Twitter Or for more mini law lessons, go to youtube.com/adage or youtube.com/Brian Heidelberger. And until next time, let's be careful out there.